What is intimidation of a witness? In Massachusetts, the criminal charge is called intimidation of a witness, juror, court official, or law enforcement officer. The Massachusetts intimidating a witness statute is very broad. It covers many situations, some that you might not expect. It is a felony and treated very seriously. Violating this statute is considered an affront to the judicial system. The system must keep witnesses safe from harm and threats if it is to function properly. Without witnesses' cooperation, prosecutions could not go forward. There are 3 elements to the statute. In order for you to be found guilty, the Commonwealth, that is the government, must prove beyond a reasonable doubt that you willfully committed some act against a person involved with a court proceeding with the intent or with reckless disregard to interfere with that proceeding. Let's take a look at each of those elements a little more carefully. The first element is that you willfully said or did something that threatened, obstructed, intimidated, harassed, misled, or attempted to or actually caused harm to another person. Another person is the second element of this charge. That person falls into certain categories. Either the person was a witness or a potential witness, had information about a criminal violation, was connected with the court system, such as a court officer or a clerk or perhaps a judge, was attending a judicial proceeding, or a family member of such a person. And number 3, that you did it with the specific intent to obstruct, impede, delay, or otherwise interfere with a criminal investigation, a criminal proceeding, or a civil proceeding. Or that you did so to punish, harm, or retaliate against a person already involved in such a proceeding. The second prong under which you could be found guilty is that you acted in reckless disregard and that your actions would impede, obstruct, delay, and so forth the judicial proceedings. If an attempted intimidation is being claimed, it is not necessary that the attempt was successful. Merely trying to influence somebody in this manner is illegal. In one case, a victim witness recanted her story before receiving the threatening phone calls from the defendant. In that case, the defendant was still found guilty, even though his actions did not change her mind. If intimidation is claimed, it is important to note that the alleged victim need not be placed in fear by the intimidating conduct. It is the defendant's state of mind that is important here, not the state of mind of the victim. The act or statement doesn't need to be overtly threatening. The jury may look to the surrounding circumstances where the statement or action took place. For example, making a motion as if taking a photograph towards a witness in a courthouse, taking a photograph of a witness's family near their home on the day the witness is scheduled for trial. Those are 2 examples of real cases where intimidation was found. Under the intentional act theory, the Commonwealth must prove that the purpose of your action was to interfere. It is not easy to determine a person's purpose, obviously. We can't look into the person's mind to determine that. But a jury will look at the actions, words, and surrounding circumstances to decide what your motives were. If reckless conduct is alleged, recklessness is more than mere negligence. Negligence is doing something that a reasonably prudent person wouldn't do. Recklessness requires the government to prove that you knew or should have known that your actions were likely to cause such interference. To convict you under a recklessness theory, the prosecution must prove one of 2 things: that you knew the likely outcome of your actions, or that a reasonable person should have known the likely outcome. We most often see this charge where you are accused of taking away the telephone of someone trying to call the police. Many clients are surprised that they have been charged with intimidation of a witness under these circumstances. That's understandable. The charges against you may sound terrible, and they are. We see them typically in domestic violence cases, assault and battery on a family or household member, as it's called in Massachusetts, where you're accused both of striking your significant other as well as intimidation of a witness for taking the phone away as he or she was trying to make a call to the police. Those two charges will both be leveled against you. The more serious of the charges is the intimidation of a witness charge. That charge is a felony and carries up to 10 years in the state prison. The assault and battery on a family or household member carries a maximum of 2.5 years in the district court. If you have any questions, please feel free to give us a call. And please visit us at affordlaw.org to see if you qualify for our reduced rates. We can help.